Hello everyone, we are delighted to welcome you to the third of our four-part webinar series in which we consider different methods of dispute resolution within the construction sector. Today's webinar focuses on adjudication. This can be described as a Back to Basics webinar series, and we intend to provide a comprehensive overview of each method and discuss the practicalities of employing each as a means to resolve disputes. Now, before we begin today's session, I've placed you all on mute to minimize background noise. If you would like to ask a question, please do so using the button on your screen, and we will reply to you once the webinar has concluded. As to your speakers today, I'm Ian Drummond, a partner in the Construction and Special Projects team in Shepherd and Wedderburn, specializing in construction and engineering dispute resolution, and I am based in Edinburgh. And I'm joined by Ross, a member of my team. Our team regularly advises on construction contract issues and disputes across a range of projects and clients. And we probably lost count of the number of adjudications that we participated now, acting for referring and responding parties, employers, contractors, subcontractors and consultants, and for adjudicators. And that's all across the full range of dispute issues, project types and contracts, and across the UK. So this wide experience helps us to form the basis of our approach and strategic advice for adjudications, and it informs what we're going to share with you today.
Thanks, Ian. We will start today with a brief review and reminder of the history and statutory basis of adjudication, and provide an overview of the adjudication process. This may be common ground for many of you, but will be useful to bear in mind ahead of the rest of the presentation. We will then share some strategic advice for those participating in adjudication, moving chronologically through the adjudication process. Some of this advice will be particularly relevant to one side, and some will be universal. We will conclude by considering some recent case law and the implications of these decisions on adjudication going forward. So the construction sector historically suffered from a high number of disputes and an adversarial approach to business. The traditional court and arbitration processes were not suited to resolving disputes mid-project. Taking disputes to the courts or to the arbitrators could, for example, disrupt contractor cash flow. Long-running arbitration or litigation would keep them out of pocket and having to fund legal and expert expenses for a lengthy period. Many companies, especially smaller ones, were unable to enforce payment or to enforce the rights to which they were contractually entitled. A 1994 report by Sir Michael Letham recommended that adjudication be introduced as the primary dispute resolution method for the construction industry. Adjudication was intended to be a quicker, cheaper mechanism for resolving construction disputes when they arose during the project. It's been described as a pay-first, argue-later mechanism, primarily intending to reach an interim determination to avoid serious disruption of the wider project. It was therefore always accepted that the process would be somewhat rough and ready. It was originally envisaged that a person of skill, such as a quantity surveyor or an engineer, would be appointed where the dispute concerned matters relevant to their area of skill. They would then issue an informal decision which allowed the project to progress. Lawyers, while not excluded as such, were never really envisaged as part of the adjudication process. It was envisaged that legal involvement would not occur until the parties exercised their right to further recourse through arbitration or through the courts. The success of adjudication has necessitated a move away from this original vision. Its popularity has resulted in more complex and higher value claims being referred to adjudication, including at final account stage post-completion. This has raised the stakes and encouraged more legal and expert involvement, which in turn has further increased the complexity and value of the process. Much more is now expected of an adjudicator. Adjudications frequently touch on specialist technical and legal issues, and parties with more at stake are more willing to test the strength of any decisions that go against them. This increased uptake in challenges to adjudicator decisions means that decisions are often subjected to further judicial scrutiny, and so adjudicators must now be able to make decisions which can stand up to this higher level of scrutiny. It can therefore be said that the role of the adjudicator has moved beyond the personal skill that was originally envisaged into something more specialist and legally rigorous. Adjudication has evolved, and it is now close to a formal judicial process. The adjudicator evaluates the cases put before them and comes to a decision, rather than investigating the facts and coming to a decision based on the adjudicator's own experience. The involvement of lawyers and experts is normal, indeed expected in many cases. The process is now more costly, and each party's costs are generally not recoverable. The general quality of adjudicators has increased across the board. However, this has been matched by a rise in their fees. There is now a large body of case law that is giving greater certainty as to the boundaries of the process, and also what is expected of both the adjudicator and the parties to the adjudication. Generally speaking, the process is one that works and continues to be used on a regular basis for high-value, complex, and strategically important disputes. This is reflected in the fact that the incidence of fresh proceedings being raised in court or at arbitration following adjudication remains relatively low, although in recent experience is growing. Adjudication is conducted on a statutory basis. That basis is the Housing Grants, Construction and Regeneration Act 1996, as amended. Section 108 of this Act provides that a party to a construction contract has the right to refer the dispute to adjudication. The dispute is interpreted broadly to cover any difference between the parties and was defined further in the case of fast-track contractors against Morrison Construction. There, His Honour Judge Thornton described a dispute as whatever claims, heads of claims, issues or contentions or causes of action that the referring party has chosen to crystallise into an adjudication reference. Construction contract is defined by reference to agreements for a wide range of construction operations, with a number of notable exceptions. These exceptions include drilling and extraction of minerals or oils and power generation works. These exceptions have been interpreted narrowly. The courts prefer to allow parties to access adjudication where possible. Equitix against Bester Generation considered a hybrid contract, which included elements of both included and excluded works, in that it was a contract to design and build an energy generating plant. The court held that this could be considered a construction contract in terms of the Act, and that the parties could therefore resort to adjudication. In the course of coming to its decision, the court dismissed the view that a certain operation was excluded if the Act did not expressly state that it was included. Instead, it was only if the operation could positively be shown to be excluded that the contract would not fall within the statutory definition of a construction contract. Domestic housing works, where one of the parties to the contract intends to occupy the property as their residence, are also excluded from the statutory regime. However, the courts have interpreted this so as to allow access to adjudication where the housing works have any commercial element to them, even when the main purpose remains domestic residence. This was the case in Westfield's construction against Lewis, where Mr. Lewis failed to persuade the judge that he intended to occupy the property as a domestic house after the construction works, and an adjudicator's award was therefore enforced to his detriment. Reinforcing the statutory right to adjudication is the regulatory scheme for construction contracts, which includes more detailed provisions on discrete aspects of the adjudication process. Parties are free to agree specific provisions themselves, but if these do not conform to the strict rules set out in the Construction Act, then they are superseded by the scheme provisions. There are separate schemes which apply north and south of the border, but generally speaking, there are no material differences between the two. Adjudication begins when one party provides another with a notice of adjudication. The parties will then agree an adjudicator between themselves, or, failing this, will consult a nominating body, such as the Institute of Civil Engineers or the Royal Institute of Chartered Surveyors. The referring party then has 7 days to provide a detailed referral notice, along with any supporting documentation, which is responded to in turn. Each party then issues one further response before a meeting or a hearing is arranged, and thereafter the parties make their final submissions. The adjudicator has 28 days in which to reach a decision. That period applies from the date the referral notice is issued. However, usually these days, the 28-day period is extended. The process is flexible. The adjudicator can allow additional submissions and can determine whether submissions are to be written, verbal, or both. The parties can agree to alter the timetable and grant themselves and the adjudicator extra time.
Now that we've set out the basics of adjudication, we will move on to consider the practicalities of each stage in the process. There are several things that should be borne in mind before proceedings are even raised. Adjudication is most effective when employed as part of an overall strategy, so as a means to an end rather than an end itself. Adjudication was not designed to resolve every aspect of a complex dispute. It's most effective, therefore, when used to tackle discrete elements of the dispute in bite-sized chunks. This makes each adjudication more focused and less expensive. For example, one adjudication could be raised to deal with an extension of time claim, then another to tackle loss and expense, and finally, a third to determine the final account overall. Commonly, as each adjudication is raised and determined, the parties' positions become clearer, and they are often able to reach a settlement, thereby saving time and money. The referring party has the advantage of deciding when to launch the adjudication proceedings. Now, referring parties should carefully choose an opportune moment to do that against the context of other ongoing discussions or other considerations such as financial year-end. I'm sure we're all glad to know that recent research confirms a decline in the use of the pre-Christmas ambush, where the referring party times an adjudication so as to take advantage of the Christmas holidays and up the pressure on the other side. But possible advantage of timing should always be balanced against the need for patience. The proceedings should never be launched, in our view, until the case is fully ready. So don't issue an initial notice of adjudication unless you know that you can meet all your deadlines and that key members of your team will be available to assist in the upcoming proceedings. As a respondent, however, you will have less control in the timing of the process, but if you suspect that an adjudication is about to be launched, there are measures that can be taken to ensure that you are better prepared. If the moment is especially inopportune, try to stall matters, for example, by participating in further discussions with the other party. But don't pause in the meantime. It's sensible to begin to undertake preparations for the adjudication and organize key resources, such as team members and relevant documents, even while discussions with the other side continue. As referring party, it can be useful to get an independent expert's opinion before you decide to launch the adjudication, especially if the claim involves extension of time, delay, or quantum issues. An expert opinion will carry more weight on specialist issues than the opinion of the parties themselves, especially if the other side do not produce a dissenting expert opinion. Although adjudication is an adversarial process, it should not be conducted in a way that sours relations between the parties more than is strictly necessary. So, for example, imposing unreasonable timeframes or unnecessary amounts of documents on the other side will undermine the adjudicator's ability to effectively determine the dispute on the basis of the submissions put before the adjudicator. This can reduce the quality of any decision which may be in your favour, leaving it open to challenge and ensuring that the process rumbles on to arbitration or litigation, all the while incurring time and expense. There is a greater chance of the other side accepting the decision if they feel they have had a fair opportunity to put the case forward. So-called smash and grab adjudications are an option that parties may wish to consider. These are adjudications in which the referring party seeks payment on the narrow ground that a notified or applied for sum has not been paid as stipulated by the contract. Such adjudications do not involve an inquiry into the true value of the referring party's entitlement to that payment. And so, Smash and grab adjudication awards can often be reversed by later adjudications dealing with proper value. However, they can still nevertheless be useful when used tactically. Should you be successful in a smash and grab adjudication, the award can represent money in the bank and can provide short-term financial benefit to a business. And it can also strengthen your bargaining position if you are seen to land the first blow. However, while this approach is often seen as a matter of course to parties who are experienced in such adjudications, other parties can see this type of approach as underhand. And so there is always a risk that the long-term cost of souring relationships by using such an approach can outweigh the short-term advantages gained. Once the adjudicator is agreed or appointed, there are a number of practical considerations that you may need to engage them with. As a respondent, if you consider that the timetable that's been set is unfair or unnecessarily onerous, raise this with the adjudicator as soon as possible. Adjudicators these days are more inclined to be flexible with timetabling to ensure that neither party is at a disadvantage, which goes some way towards explaining the decline of the Christmas ambush that I referred to earlier. If the timetable as fixed is still unreasonable, then object to that without delay. A timetable can be objected to on the grounds that it constitutes a breach of natural justice, and the failure to make an objection at an early stage on that basis can, however, prejudice the ability to object to the eventual decision on the same ground. If a problem with the notice of adjudication or referral notice becomes apparent, for example, because there is an error in the parties' names, or there is a problem with the service of papers, or any aspect of the adjudicator's appointment, the referring party should seriously consider reserving the notice and starting again, because such issues are likely to undermine the adjudicator's ability to determine the dispute and to produce an enforceable decision. So, reserving the notice will forfeit the nominating body's application fee and set the process back a short time, but these costs will normally pale in comparison to the possible implications of a jurisdictional challenge being raised to the eventual decision and the potential that the decision could be unenforceable in court. As a respondent, if potential jurisdictional issues are identified, then consider whether they should be raised or whether it be more pragmatic to allow the claim to be resolved one way or another. If jurisdictional challenges are to be made, it is important to reserve these arguments within your written submissions or communications with the adjudicator, and that is to ensure that they can be raised again at a later stage should you choose to do so when enforcement proceedings are ongoing. Adjudicators are becoming more nervous when it comes to jurisdictional challenges and are more likely to uphold such challenges now and resign rather than continue on a potentially challengeable basis. This is in part because adjudicators who produce an unenforceable decision due to jurisdictional problems may not be entitled to their fees, although that depends on the terms of their appointment at the outset. Jurisdictional challenges can be used to buy a respondent more time to investigate matters and build a defence, or tactically to simply land a blow on the opponent with a view to enhancing a negotiating position. Such challenges commonly refer to the following. Firstly, contractual notification requirements for the notice of adjudication perhaps not being complied with. There being problems with the adjudication appointment process and timing, or there being a question as to whether the matters raised in the adjudication notice are actually in dispute to start with. And finally, whether the project concerned falls within one of the exceptions to the adjudication regime. However, there is a danger in making what might be seen to be spurious jurisdictional challenges, as these will likely frustrate the adjudicator from the outset, with the danger that any sympathy for that party may be damaged.
Adjudications typically involve a high volume of documents, so thorough preparation and effective management of these documents is vital. The referring party should carefully set out the background and the issues in dispute, and focus the questions that it is asking the adjudicator to determine. Orders sought should be specific orders, but should still allow the adjudicator room to manoeuvre. Parties should remember that orders sought can be declaratory and don't need to be restricted to awards of money or time. Referring parties should submit signed witness statements supporting critical factual matters. Adjudication is akin to a judicial process, and the referring party has the onus of proving its claim and the facts on which that claim is based. These can, and often will, be written by legal representatives, but should be in the words of the witness. Witness statements are, of course, also useful for the respondent. Vouching and relevant evidence that supports the factual claims made should be submitted along with the party's submissions. Don't presume that summaries of the evidence will suffice. Parties should also make sure that the referencing within the submissions is clear enough to the adjudicator. The importance of referencing was highlighted in the case of Broughton Brickworks against Parkinson. A vital email, which the adjudicator admitted would have changed his decision, was not consulted by the adjudicator as it was buried amongst a sea of productions, and references to it within the submissions were incorrect. The courts had no sympathy and enforced the adjudicator's decision, stating that the onus is with the parties to ensure that the relevant evidence is clearly and carefully presented to the adjudicator. There are also a number of general strategic points to make regarding written submissions. Respondents should put all lines of defence into a response to the referral, including potential counterclaims and set-offs. In general, it is not a good strategy to hold back information or arguments for later in the adjudication process. Furthermore, any arguments not raised in defence in the adjudication will not be able to be raised later at enforcement stage. Respondents should tend to focus their arguments on the key points, unless their position on these points is weak. If the respondent considers that its defence is weak overall, then a strategy can be to throw mud in the hope that some of it sticks. If you do decide to take the approach of only focusing on the key points and arguments and not responding to immaterial points, make it clear in your response and use this to your advantage. Don't introduce new points and arguments unless you have to, as this will likely allow the other party a chance to respond to these new points. If, at any stage, either party realises that the position is weaker than initially thought, do consider whether it is worth seeking a settlement in order to mitigate risk. An adjudicator has the power to allocate their fees, so if you lose an adjudication, you are likely to have to pay the full fees of the adjudicator, which can be many thousands of pounds in a complex adjudication. And this has to be paid on top of any other award the adjudicator chooses to make. We would tend to advise clients to seek a hearing in a complex claim, although this is at the adjudicator's discretion. An adjudicator might not appreciate the full colour of the dispute just by reading written submissions and witness statements. If you have credible and impressive witnesses, this is better demonstrated through a hearing than through witness statements, even bearing in mind that hearings are almost certain to be conducted virtually, given the current circumstances. A hearing can be used to ensure that the adjudicator picks up on and is giving due consideration to all the points that are key to your case. If you consider that the adjudicator is missing a point that you consider important, a hearing allows you to address this in real time. It is less practical and sometimes impossible to address an oversight of the adjudicator once the decision has been published. If a hearing is called, we would of course recommend that you attend it. In addition to all the benefits I have just set out, the decision in Ryden Maintenance against Affinity Sutton Housing shows that the hearing could go ahead anyway, with only one party attending. Parties should ensure that they are properly prepared for the hearing. Attendees should be chosen carefully. A potential attendee's knowledge should be balanced against other factors, such as robustness, to ensure that their attendance has a net positive effect on the case. The parties should consider the topics that are likely to come up and decide who will speak to what. All attendees should be fully up to speed with the procedure and how to conduct themselves. The importance of answering questions truthfully, not being evasive in their answers, and maintaining a level head should be made clear to attendees. Virtual hearings pose additional concerns, but these can also be addressed by proper preparation. Parties should ensure that their legal representatives and their witnesses and any other attendees all have the necessary IT equipment and know-how to access a virtual hearing. We would recommend that all equipment is tested in advance and that all parties are familiar with the virtual platform that the hearing will be conducted on. An adjudication hearing may provide an opportunity to ask questions of witnesses if you consider this necessary and justified, but be prepared to articulate a strong justification for doing so, as you will likely meet resistance from both the other side and the adjudicator. You should always be alert to any opportunities to attack the case of the other side. If it seems that attendees from the other side are not particularly robust, or if they seem sympathetic to your case, you can draw this out and create a favourable impression with the adjudicator through the use of proper questioning. You should be vigilant to the points made by the other side. You should be prepared to challenge any points that you consider untrue and which can be, for example, contradicted by documented evidence. If you can identify any issues with the credibility or the reliability of the witness evidence of the other side, draw attention to this when making your submissions. Adjudications often come down to witness evidence, and credibility and reliability can prove crucial. You should have conviction in your case, but this is not to say that you should not consider conceding certain points if they are beyond rescue, particularly if doing so is of no great consequence. If an issue arises at the hearing which cannot be answered there and then, do request the opportunity to cover it in a further written submission, whilst allowing for the likelihood that the other side will have a chance to respond. Once the decision has been issued, it should be examined carefully. The parties have 48 hours to inform the adjudicator of any slips, such as obvious arithmetical errors, and seek that these slips be corrected. As a respondent, if the decision does not go your way, you should consider whether you are able to negotiate a better result, or whether it is worth taking your chances at the enforcement stage in court.
We will now move on to discuss some recent case law relating to adjudications and the implications that these could have on adjudication practice. In July of this year, 2020, a landmark decision of the Supreme Court in Bresco Electrical Services against Michael Lonsdale held that a party in liquidation has the right to pursue an adjudication, but that it will be for the judge at the enforcement stage to decide whether the adjudication's decision should be enforced. Stiles and Wood against GE CIF trustees, a case which followed the Lonsdale case, that is the first case in which an adjudication decision in favour of a company in liquidation was enforced. And there, key to the decision to enforce was the fact that the company in liquidation had provided adequate security to protect any future cross-claims by the defendant. Stiles and Wood proposed to ring-fence the awarded sum for 3 months and to take out an after-the-event insurance policy to cover any potential adverse costs in subsequent proceedings. The judge found those measures to be satisfactory, and the judge also found their estimate of costs, which differed greatly from that put forward by GE CIF. This judgment shows that the courts will enforce adjudication decisions in favour of companies in liquidation. However, each case will turn on its facts and in particular the security that's being offered. As more companies are predicted to enter liquidation due to the effects of the COVID pandemic, parties on both sides of a liquidation should take note of these rulings. Liquidators seeking to enforce an adjudicator's decision should consider whether they are able to provide the requisite securities. And for parties seeking to resist enforcement in those circumstances, this case This last case provides a warning that a broad brush approach to cost estimates will likely not be tolerated by the courts, particularly if the challenge to enforcement alleges that there is insufficient cost protection, which was the case in this last case we mentioned, the Stiles and Wood case. Earlier, we discussed smash and grab adjudications and their place in resolving disputes. Now, their effectiveness was further underlined by the decision in Q Holdings against Donald Insall, a recent decision. Donald Insall are an architects firm who'd been employed by Q to convert the King's Observatory in Richmond into a private residence. A dispute had arisen regarding unpaid fees, and Donald Insall had conducted a successful smash and grab adjudication on the basis that they were entitled to payment in full purely as a result of Q's failure to adhere to the strict contractual requirements governing payment. The adjudicator was therefore not bound to consider the valuation of the underlying works at all in coming to the adjudicator's decision in Donald Insall's favour. Q thereafter refused to pay and then raised a professional negligence claim which sought to revalue the works for which payment had been awarded in the adjudication. Donald Insall argued that Q were obligated to make payment of the adjudicator's award before raising their professional negligence claim, and that as such Q's claim should be struck out as an abusive process. The court held that Q's decision to raise proceedings without having made payment of the adjudicator's award was in flagrant disregard of the pay now, argue later adjudication regime and amounted to unreasonable and oppressive behaviour. The court therefore ordered Q to pay the adjudication award sums due to Donald Insall, but did refrain from striking out Q's new professional negligence claim, ruling instead that that latter claim should be paused and then resumed once payment of the adjudicator's decision was made. So this case underlines the continued relevance of smash and grab adjudications as a tool to be considered when a construction dispute arises. Finally, we'll finish on our topical case, which is that of Millcrest Developments against Waters, which concerned an application for an interim injunction to prevent a homeowner from continuing with an adjudication. Millcrest had carried out building works on Ms. Waters' property, which commenced in 2017 and continued until an uncertain date in 2019. With what proved to be unfortunate timing, Ms. Waters commenced an adjudication on 23rd of March 2020, contending that the works were defective and that she had overpaid Millcrest by around £45,000. That evening, of course, the government announced that the country was to enter lockdown. The adjudicator duly proposed a timetable, with Millcrest's response to the referral notice due some 2 weeks afterwards. Millcrest, however, objected, claiming that it was not able to comply with these deadlines at a time of national crisis, and proposing that no adjudication in accordance with the rules of natural justice could take place before the end of the COVID-19 pandemic. However, finding his objections dismissed by the adjudicator, firstly, Millcrest then applied to the court for an interim injunction to stop the adjudication. Now, injunctions are only granted in adjudications in very exceptional circumstances because they can be seen to frustrate the statutory right to refer a dispute to adjudication at any time. The judge concluded that to conduct the adjudication in the manner proposed by the adjudicator would not be a breach of natural justice, and therefore the judge dismissed the application for injunction. Given the high bar for granting injunctions, it is not surprising that the application was dismissed, but the decision is interesting for other reasons. Because in reaching her decision, Mrs. Justice Jeffers opined that many of the pressures that Millcrest claimed they were under as a result of the pandemic are pressures which arise under the normal course of conducting adjudications in normal circumstances. And so, for example, difficulties in organising time with witnesses to take statements, logistical challenges in obtaining and transporting documentation, and maintaining the interrelation between a quick adjudication and a heavy workload, she held are par for the course when it comes to engaging in adjudication in normal times. So in other words, life might seem at a standstill, but what we might say is the business of dispute resolution in the construction sector rumbles on. We hope that this presentation has been interesting and useful for future practice. So that ends our formal presentation. There is an option, as we said earlier, on your screens to ask a question should any arise out of the topics we've covered today, and we'd be happy to answer any questions, and we'll endeavour to get back to you on those as quickly as we can. An on-demand recording of this session will be shortly shared with you all, should you wish to watch it again or share it with any colleagues. And I'd just finally wish to say thanks everyone for listening, and just to remind you that the last webinar in this series is taking place on the 22nd of December, shortly before Christmas of course, and that will cover mediation in the construction sector. So we hope to see you all then. Thank you.